Hi, everyone. This is Jan Brownlee with Assurix Global. I'd like to welcome you to today's webinar presented by Curt Pearsall entitled Producers, a Key Player in Developing a Strong E&O Culture. These webinars are for E&O Plus insureds and their invited guests. We trust if you're on the webinar today, you are an E&O Plus insured agency or an invited guest of one of our insured agencies. During this presentation, you will be in listen-only mode. If you have any questions, please type them in the control panel and we will address them at the end of the presentation. This webinar is being recorded and will be made available for those that are unable to join us today. Our presenter is Curt Pearsall. Curt is president and founder of Pearsall Associates, a risk management consulting firm specializing in helping agents protect themselves. He is the former SVP of Utica National's Agents E&O program, where he oversaw underwriting, marketing, services, and claims divisions from 1987 to 2009. Please welcome Curt Pearsall.
Well, Jan, thank you very much for that introduction, and good afternoon to all of you. Maybe good morning to some of you on the West Coast. It's certainly my pleasure to be with you folks today, and hope you are all safe and healthy, and your families as well. So, but we've got a tremendous turnout for today's session, and we've got a lot of material to cover. So let's get into it. I chose this topic, producers, as a key player in developing a strong E&O culture. Typically, when we look at E&O claims, oftentimes, probably more often than not, there's a producer element to the claim, to the E&O claim. Something that was said, something that wasn't done, whatever, but that there's some role that the producer played in that E&O claim. So the focus and the goal of this webinar is to help producers understand some of the finer points of maybe their role, some of the things that they need to be sensitive to, etc. I think you'll see as we go forth, once again, we've got a lot of material to cover, but I think you'll find this to be very beneficial, very educational, and certainly something you can put in practice very often and very soon. So, as we typically do, we always start with a little bit of a look at the claim count for the E&O Plus program. These are the top 5 causes of loss going back for the period of 2013 to 2019. And as all E&O carriers will probably state, that exposure screening, exposure analysis is the #1 cause of E&O claims. As you can see, 21% over this 6-year period of time. Interesting, and I always bring this issue up, and we're going to talk about this as one of the issues today, claim handling. Claim handling, since actually the E&O Plus program started back in 1986 and over the last 6 years, claim handling has been one of the top 5 causes of the E&O claims. And so the way that agencies handle claims tend to, there's certainly the potential there for those actions to generate E&O claims. And this gives a little bit more of the detail behind that. And then when we look at the first graph that I showed was the total number of claims. This now gets into the total dollars that are involved, and I'm not sure what the total dollars are here, but as you can see, that exposure screening generated 21% of the overall number of claims, but yet generate 54% of the total dollars that the E&O Plus program has paid out in defense cost as well as judgments against the agency. So it tends to be, as I will reference it during the session, it's probably the closest thing to a silver bullet in preventing E&O claims. And I think that's something hopefully all agencies will, all people that are on this session today will kind of take note of. And when we talk about producers, I mean, a lot of times people will think of, the outside producers or whatever, but yet this really does apply to anybody that's within the agency that is dealing with clients. And we're going to talk a little bit about be careful what you say, things of that nature, et cetera. So really, when I say producers, it could be the new business producer that's out, visiting the clients. It could be the people in the office that are doing some cross-selling, things of that nature. So I think you'll see it'll cover quite a bit of those areas. Now, I always like to start out with, and I always find it interesting that many people do not really know what the legal standard is that insurance folks are held to. So I always try to start off with this. So as you can see, the standard of care that's applicable to brokers and the duty a producer owes to its insured in most jurisdictions. That's kind of my disclaimer. It doesn't mean it's going to apply to all, but I would say the vast majority, this definitely applies to. New Jersey always seems to be a little bit of a different, they tend to hold insurance agencies to a little bit of a higher standard. But as you can see, the legal standard includes purchasing the insurance that the client has requested you procure, or advising the insurer their inability to do so. So in other words, that's why it's important that when you are out visiting with a client, what are they asking for? And we always stress the importance of taking notes. What is the client specifically saying that they want? There's been many, many, many E&O claims where the producer wound up providing the client with a policy. The problem is it didn't cover what the client asked for. So it's important that producers listen to what the client is asking for and to get them the coverage that they are asking for. And if you cannot get them that coverage, you need to let them know. There was an example a number of years ago, just one to help bring up the point, where the client asked for a D&O policy, directors and officers policy, that did not have an insured versus insured exclusion, which is probably a typical exclusion in a D&O policy. The broker wound up getting them a policy, a D&O policy. The problem is it still had the exclusion in it. And when a loss occurred and the loss was denied because of the exclusion, the broker was eventually found liable for not getting the coverage that the client specifically asked for. So once again, you have to listen to what they're asking for. If you can't get it to them for them, you have to let them know. Second thing, your responsibilities are to obtain coverage which is not void. And what I mean by not void is, an insurance contract or policy that does not have any legal validity and is therefore unenforceable in court. In other words, maybe it was a minor that signed the application. Well, minors aren't going to be held responsible for that. It could be a situation where the policy was procured using false information, and thus the carrier may say, well, the application did not accurately represent the risk, so we're going to declare that policy void and give you your money back. Producers are obviously trusted with providing carriers with honest information, so that way they can underwrite and price the risk appropriately. Another issue that's part of the legal standard is to obtain coverage which is not materially deficient. Okay, an example of that, and it's actually one that I have used in my blog that I have done, is a situation where an agency is trying to get coverage for a general contractor. They wind up getting them a policy, but the policy had an exclusion in it that if the general contractor built more than 10 homes in that development, they had no coverage. Well, the general contractor was building all of the homes in the development. So that would be a situation that, yes, you got them a policy, but it really didn't cover much. So that would be kind of the not materially deficient. And then obtaining the coverage undertaken to be supplied at the requested limits. So in other words, the client says, I need X limits, that you wind up providing them with that coverage. So they say, well, we want 500 CSL, you got them at 250, 500, 100, or whatever, reverse. It could be a situation where you didn't get the client the coverage that they asked for. So that's part of the legal standard. A couple of the other issues that producers are typically going to be held responsible for. You should not make any false representations about the benefits, advantages, conditions, or terms of any insurance policy. In other words, don't mislead the client that the policy is going to do something that it's really not going to do. Also, no agent shall sign or allow an applicant or insured to sign any incomplete or blank form pertaining to insurance. I remember back in my early days in the insurance business back in the late 70s, when I don't want to say it was more common then, I think it still unfortunately happens today, where producers say, well, here, just sign the application and I'll fill it in later on. And we're going to talk a little bit about why that has no bearing or no applicable defense for the agency if something happens down the road. So we'll talk a little bit about that. So you just want to make sure that, if you're going to have the insured sign an application, make sure that the application has been completed. No agent shall engage in unfair claim settlement practices. What's an example of that? Saying, well, you haven't paid me the premium, so I'm not going to submit this claim. That would be considered an unfair claim practice. Misrepresent pertinent facts about coverage, fail to acknowledge and act promptly upon communications as to claims, or arbitrarily refuse to pay claims. So those are a couple of the other legal standards. Now, as with all E&O claims that occur, there are defenses that the agency could use. And the goal is always to make sure that you have, you have some strong defenses to help you in any kind of litigation that's going to incur. Now, one of the typical duties or agency defense is that plaintiffs, if they fail to read their policy. Now, in many states, an insured has a duty to read their policy. It's not a slam dunk if they don't, but it's certainly going to help your case if the client should have noticed maybe the vehicle that was missing, or it was a wrong address on the policy, that they should have noticed that, and by failing to read the policy, they have some degree of liability. Plaintiff failed to give accurate information to you as the agent. They tell you that, yeah, I have a dog. It's, and maybe it's in reality, it's a breed that many of the carriers are underwriting against. And maybe it's a pit bull or a German Shepherd or a Nikita, one breed that the carriers are not really looking for. But they don't tell you it's a pit bull. They tell you it's a Chihuahua. So they failed to, the client failed to give you accurate information. Maybe they misrepresented certain facts. Well, they didn't tell you that they put an addition on the house. So that you could not do the proper square footage valuation because they didn't give you the correct information. Or the last one, and this kind of gets to this whole blank application issue, if the plaintiff signed the policy application containing incorrect information, they will be held responsible for the contents of that application. So once again, if they signed the application but it was blank, well, you can't hold the client responsible for the contents of an application if there was nothing on that application when they signed it. So, if the client signs an application, they're going to be held responsible for the accuracy of the information on that application. So this whole issue of making sure that insureds do in fact sign applications is very, very strong. It's something, and you probably have heard that as a producer. You probably, well, try to get the policy holder to sign the application. Well, it really makes a huge difference. So if you can get that done, it certainly strengthens the agency's defense. Now, that's kind of the basic standard. There is a circumstance called a special relationship. And as you can see here, that if there are certain circumstances that prevail, the client may be able to hold you to a higher standard. Maybe intimate knowledge of a client's personal or business endeavors. They've got multiple businesses, you write them all. As a producer, think about the accounts that you have. Now, if you just wrote the account yesterday, well, they may not be able to allege a special relationship. But if you've had that client for the last 30 years and you write all of their coverages and something happens, they may allege that there was a special relationship. And if that's the case, they're going to potentially have a stronger case of holding you to position of an advisor. So now this is going to happen. It's not something that you probably want to avoid it if you can, but it's probably not going to be possible at times. Now, many of the E&O cases involve allegations or conversations where the client stated that they were advised that they had certain coverage or that they had the limits that they had asked for. Producers need to be very, very, very aware of the fact that you can be held responsible for what you say and what you put in writing. So if you were to tell a client that maybe under the whole issue that the industry is currently going through with the business interruption and whether the pandemic or civil authority, if you said, well, there's no exclusions to this, everything would be covered. Well, you could be held responsible for what you say. So you want to be very careful that you don't misrepresent, once again, the coverage. Now, here's an example. And in the May webinar that I did, where we talked a little bit about how do agencies promote themselves, I brought up a number of these issues, and this happens to be one of them. So for example, if you were to say that I'll ensure that all of your risks are covered. Well, all sounds like a pretty powerful guarantee. Now, so if the client suffered a loss involving an exposure that the agency did not identify, i.e., business interruption, pandemic, civil authority exclusions, or whatever, it could be alleged that the agency overpromised their abilities. So overpromising, I know it sounds very impressive, but, and this is a big but, if it's not reality, it could be held against the agency if a problem developed. So we're going to talk a little bit about now your role as a producer. And I think it's very important. And the agencies that I'm honored to work with the E&O Plus program, and I do hear this from time to time. It's like, I think some folks say it's like we're not all on the same page here. The producer's doing their thing and we're supposed to be doing our thing, and we're just not blending together. Well, producers need to clearly understand that they have a role and what the expectations are of them by the agency that they're working for. Now, this could vary from one agency to another. It could vary based on the division you are working in within your agency. They can involve a variety of issues, tasks, responsibilities. In other words, is it your job to get the exposure analysis checklist completed, or is it somebody else's responsibility? When you go and make a sales call, is it your responsibility to take notes, or should you be bringing somebody with you to take notes? Those are some of the types of issues. So producers need to understand what exactly is the role that you are being asked to fulfill, and how well does that mesh with the other divisions. Producers, as I started with the conversation, producers are an extremely important part of the overall equation. There's a reason why a lot of E&O claims involve the role of a producer, is because that's how important of a role that you do play. So for the process to be effective and efficient, everybody, and this includes producers, needs to honor and perform their role within the agency. And if you're not, and it's like, oh, I thought you were doing that. Well, no, I thought you were. And all of a sudden now there's some miscommunication. That's how things fall through the cracks. Things don't get done, etc. Continuing on with some issues involving your role, once again, some things including key issues such as the exposure analysis, which I talked about, documentation, discussions at various times, claims involvement. We're going to talk a little bit more about the claims piece and why at times claims handling within the agency does in fact become a major cause of E&O claims. And then we're going to also talk about application development. Other issues involving the role of a producer, once again, this could vary from one agency to another, etc. Could vary based on how long you've been at the agency. Do you have an assistant or whatever? The review of the carrier and wholesaler proposals. So we're going to talk a little bit about more detail on that. So I'm not going to get into that detail necessarily now, but the review of the responsibilities and the communication to other members of the team. Once again, you are part of a team. And for that team to function properly, everybody needs to perform their role to the best of their ability. Policy delivery could be a role that a producer is going to play. So we're going to talk a little bit about that. And then we're going to talk a little bit about honesty and how important honesty is in the overall role of a producer. So let's talk a little bit about getting applications signed. Once again, the E&O benefit of a signed application: clients, customers will generally be held responsible for the contents of an application if they signed it. So if there's a misstatement on that application and the client signed it, they're now held responsible for that error. This protects the agency for any misrepresentations the client may have made. If they didn't sign the application, they could allege that they had no idea what you put in the application that was submitted eventually to the carrier. So once again, getting a signed application is a tremendous E&O loss prevention approach. Claims involvement. As I mentioned, since the beginning of the E&O Plus program, claims has probably been, I think it's the #2 cause of all E&O claims. The way the agency handle claims is causing E&O claims. In the last 6 years, it's the #4. So it's a very predominant issue. So let's talk about a possible claim. A client brings to your attention, a question such as, well, would a claim like this be covered? Well, and from time to time, you're probably going to get your clients posing that type of a question to you. It's like, well, let me tell you a hypothetical. Would that be covered? Well, you need to be very careful how you respond to those. Some of them may be very legitimate questions, but some of those inquiries could be a trap. But what I mean by a trap is that there's a possibility that the claim has already occurred and the client's trying to find a way to get it covered. Now, if you said, well, yeah, that would be covered, you need to be very careful. We're going to talk a little bit about that. Once again, now you could be held responsible for what you say or what you put in writing. So sometimes what the client will do is that they'll try to get you to make a judgment call on a particular claim scenario by not providing you with all the information. So based on what you know, yeah, that would be covered. Well, you want to be very careful with that. The best approach is to comment that, one, you're a producer, you're not a claims person, and that's not meant as a disservice to your role. It's just, your agency has professional claims staff that are dedicated to handling inquiries such as this, and they know how to handle these. They know the process to go through. And then obviously, whether a claim is covered depends on all the facts of the claim. And sometimes, from time to time, you may find a client that they give you, out of the 10 pieces of information, they give you 6. Well, they're going to tell you the 6 that maybe are most beneficial to them. And they may not tell you some of the key issues that would, once again, kind of preclude coverage. So you want to be very careful. You do not want to be stating that, yes, that would be covered, because once again, you may not have all the facts. So on actual claims, due to your role as being the lead person that secured the account, there's a good chance the client's going to call you or write to you to say, well, I've just had a claim, etc. Well, I understand that. And that's common. That's because, once again, that's the role that you play. You sold them the account. You're the name that they're going to be most comfortable and aware of. While this is understandable, it's best to avoid any significant coverage judgment discussions and look to get your agency's claim staff, your professional claim staff, involved as quick as possible. So if you have any kind of discussion with the client, and maybe it's best to say, honestly, before you get into giving me a lot of the details, let me get you over to our claims folks, or I will have them contact you. If you do get into any kind of discussion and you've made certain judgments, make sure that you bring those to, your claim staff's attention. It's like, well, based on what he told me, I told him that he would have coverage. Well, you want to make sure your claim staff know any of the details that you've had with that client. So, and it's always best to provide that in writing. That way they've got that information. Now, the key issue for a lot of the folks and, producers, and actually for your claim staff and your agency are aware of this, that technically only the carrier can officially determine whether a claim is covered. Agents really have no authority to approve or deny a claim. Those are carrier responsibilities. So it's best to, once again, if you're brought a hypothetical or an actual claim, get those to your claim staff and let them follow the process that they've been told to follow. Now, this is a common issue, claims made. And back in, I believe it was in February, the E&O Plus webinar that was done was on the issue strictly of claims made coverage, because it has generated a fair amount of E&O claims because of some of the misunderstandings. So the trigger of what constitutes a claim is obviously a very important issue. And these triggers can vary from one claims made form to another. They're not necessarily going to be the same. It could be notice to the carrier as a trigger. Some policies, it could be notice to the client as the trigger. So if approached by your client as to whether these circumstances constitute a claim or not, excuse me, the best approach is to get your claims department involved. Once again, you've got professional claims staff, get them involved, let them take that claim and kind of run with it. Excuse me. Most chances, most likely, your claims folks will probably advise the client, let's submit the claim and let the carrier make that decision. It's never a bad thing to take that approach, because if the carrier says, well, no, that doesn't constitute a claim, okay, well, they've made that judgment call, as opposed to you making that judgment call and find out that you were not correct. Also, some claims made forms are claims made and reported. Well, claims made and reported, they sound the same, but there are some differences between the two. So claims made and reported has some very specific timelines for when claims need to be reported. So producers need to be very sensitive to those. And in the webinars that I've done with the program over the last, 7 years, we've talked a little bit about, a claim coming into a producer. They didn't think it was covered and never submitted the claim, and then to find out that it would have been covered, and the carrier then denied the claim for late reporting. So exposure analysis. We talked in the beginning, it generates 21% of the claims, generates well over half of the dollars that are spent on the program. So performing an exposure analysis review has been viewed as the closest thing to a silver bullet in preventing E&O claims. It's clearly one of the most important things an agency can do to minimize the claims potential, because typically it's what's not covered that's going to generate the E&O claim. If it is covered, well, maybe it's not fully covered, but if there's at least some coverage, maybe the E&O claim is going to be, it's not going to be as severe. But if there's no coverage whatsoever, that has a greater chance of resulting in an E&O claim. Thus, the more exposures that are covered, so the more insurance that you have sold or offered but declined, the less E&O claims potential there is. So once again, the big advantage of an exposure analysis checklist is by bringing to the client's attention various issues, exposures, and we're going to talk about a couple of those in just a second. You probably, for example, let me give you one. Okay, you've got a contractor. Well, are they using a drone? Well, maybe they're going to say, well, yeah, we've started using a drone. Why? Is there a problem there? Well, you need to find out, to what degree does your liability policy cover the aircraft? I've heard that there are some policies now that are providing some limited coverage, but that's going to vary from one carrier to another. So all of a sudden you say, well, let me get you a proposal to cover your drone. Now all of a sudden you potentially sold more insurance, and by covering the drone exposure, you've now somewhat reduced your E&O exposure as respects the drone. So, the more exposures that are covered, the less E&O claims potential there is. This issue gets to the changes that your clients are going to go through from year to year. And that's why we look for an exposure analysis review, a checklist to be done on a renewal basis. What I call new exposures, it could be, well, this exposure really was not in place last year, but maybe it is now. Drones, I just mentioned. Business interruption and the contingent business interruption. Actually, the contingent business interruption was one of the biggest issues that was addressed by Allianz in a survey that they had done. I think it was back in 2015. It was the #1 issue of concern among risk managers, because a lot of your clients are probably getting a product or service from another party from another or another business. And if that business suffers a loss, a fire, they're shut down. Now your client is not going to be able to get the product or the service that you need. And now that's called contingent business interruption. Active shooter coverage, we've talked about that. That was actually talked extensively at the last E&O Plus conference. And product recall. I hear from time to time, and actually I've had, when I've brought that issue up, I've had a number of folks, Plus producers write to me afterwards saying, they had, I know there was a potato chip manufacturer, and she said, I never offered them product recall. And she wound up offering them product recall coverage. I don't know whether she sold the account or not, but she felt comfortable that she was at least addressing the exposure. So now standard checklists, questionnaires are designed to be used, and I think every agency is looking to try to make these checklists and questionnaires more user-friendly. It does take time, but the goal is to show your clients that you are concerned about risk management and you're trying to help them understand the insurance that they have. Now we're going to talk a little bit about internal communication. So once again, producers, you're not out there on an island. You are part of a team, and that you're not operating independently. You have a team back in the office that you are working with, whether it's to market the account or to provide ongoing service. It could be the claims issues that I've addressed a little bit. You're part of a team, and you may be one of the more important pieces of the team, but nonetheless, there are other people on the team that need to be kept informed as to what's going on. So to keep the team informed on issues that arise, client questions, coverage issues, if there's any, you go out and you meet with the client. Well, what was discussed? Are there, minutes of any strategy meetings? Well, your internal staff need to understand, they need to know that stuff so that way they can do their job. And once again, we've talked a little bit about claims involvement. So this level of communication really is invaluable, allows everybody on the team to feel informed and part of the team. So once again, producers, you're a very, very important part of the team, but the bottom line is that you are one person on that team. Education and knowledge. As I mentioned early, and I've mentioned it frequently in different webinars, because this has come up so often on E&O claims where a comment that is made by a producer or by an internal staff member, that wasn't correct. You can be held responsible for what you say and what you put in writing. So it's important that you understand the issues and communicate, accordingly. If you don't know the answer to a question, it's okay. Just find out the answer and get back to the client. So once again, this takes on a very vital role of importance when you're communicating with your clients. They're looking for your knowledge and your expertise. They know their business. Maybe it's a hardware store. They know the hardware store business, but they don't understand maybe some insurance issues. So they're going to come to you and they're going to be looking for your knowledge and your expertise. And obviously that's going to be the basis to help them make the important insurance decisions that they will need to make. Now, there's an old adage that's still applicable: sell what you know and know what you sell. So if you're not 100% confident in the knowledge of the products you're discussing, secure that knowledge or bring in a subject matter expert. And I've seen a number of agencies that, if a topic comes up, maybe it's, with a client and they're going to start to ask some questions about directors and officers. Well, so you want to bring in, say, well, let's schedule another time for me to bring in my directors and officers manager back in the office. Now you're bringing in some expertise as opposed to you making a comment that may not be correct. So if your client asks a question, once again, if you're not 100% positive, it's okay to say, hey, it's a great question. Let me find out the answer and I'll get back to you. It's okay. I think some folks try to feel like they need to have all the answers. It's getting much, much tougher in the business. There's so much exposures. Once again, you've got issues. I mean, how many folks, on the whole business interruption issue with some of the exclusions, I mean, that has taken on a whole new life. I'm not sure a lot of folks maybe were aware of that before. Questions such as, does my general liability policy cover my drone? Well, how you answer that question could make a difference if a problem develops down the road. If he said, you know, honestly, I don't know, let me check that policy and I'll give you a call back. Because once again, the one thing I always say is the one thing you don't want to have happen, you don't want the client to have better documentation than you do. And if you say, well, yes, you're covered, they're probably, when you leave the office, they're probably writing down, you know, spoke with Joe regarding the drone. He said, I've got coverage. Well, and if in fact something happens and now there is no coverage, he's going to remember that conversation. So, you know, as a producer, it's very difficult to know everything about everything. So, you know, if there's an area that you feel that you are maybe not as strong on, you know, identify those areas. Get in touch with your manager. It could be issues such as the cyber, it could be claims made, which once again has caused its share of problems, business interruption, professional liability, ordinance and law coverage, miscellaneous forms such as protective safeguards endorsement. It's interesting. I was looking at some claim files or loss runs today, and I noticed a number of E&O claims involving pollution. So, you know, or lack of pollution coverage. So if that's an area that you're not as strong on, you know, tell your manager, hey, can you get me some more knowledge, or who do we have that would have some knowledge on pollution? I need to get become more knowledgeable on that topic. Another suggestion, you know, and you know, this is my 46th year in the business. Back when I started the agency side in 1975, I was taught to read policies. We would read the fire policy from front to back. We would read the package policies from front to back. That's how we got to know what was covered and what was excluded. I think personally, it's a little bit of a dying art. I think there's tremendous value to knowing what your policies cover and what they don't cover. You know, the insurance industry is blessed with some great periodicals. So maybe look at reading some of these various insurance periodicals, and then maybe look at some coursework such as CIC, CPCU, etc. Now, as you know, it takes 20 years to build a reputation and 5 minutes to ruin it. Talk a little bit about honesty. If you think about that, you'll do things differently. That was just a quote by Warren Buffett. Next quote is one that I was told, that they will only know that I didn't know what I was talking about if they have a claim, and what are the chances of that? Back at the agency that I worked at, I went on a sales call, and the owner of the agency, they were talking with the client, they were talking about aircraft coverage, and the owner of the agency totally misstated how the coverage would apply. And when we got in the car, I reminded him of the fact that that's not how the aircraft policy would respond. And this is exactly what he told me. They'll only know that I didn't know what I was talking about is if they have a claim, and what are the chances of that. Probably not a statement that you want to have connected with you. So that was an owner of the agency that I worked in. So honesty, to a large degree, the relationship between you and your agency, the carriers that you do business with, it's built on honesty and trust. So, you know, when you're completing the application, you know, how are you getting the information to complete that application? Is, you know, are you asking the question? Are you kind of guessing at some of the answers? There's been a number of E&O claims that have occurred because of issues such as incorrect overall description of the risk, incorrect loss history, issues such as was the account non-renewed. While there are some carriers, probably more so on the personal line side, that actually have an underwriting guideline that says if the risk has been non-renewed, you know, they don't want it. And if all of a sudden they find out down the road that your agency lied on the application and the account had in fact been non-renewed in the past, they could deny those claims that occur moving forward. So very, very important issue to make sure that applications do get completed correctly. So let's say you complete the application and it's submitted, and all of a sudden the underwriter comes back and says, I got a couple questions for you. And now you may think you know the answers to some of the questions, but there may be some questions that it's like, well, I'm not quite sure. Well, the one thing you don't want to do, you don't want to guess at the answers. Just say, you know, honestly, let me take down those questions. I'm going to contact the client, and I'll be back to you later in the day or tomorrow with the answers. I think that's the proper way to handle it, to make sure that you are providing the client or providing the carrier with honest information for them to be able to price the risk and to underwrite the risk. Documentation. Producers, in honesty, the one area that I think all producers need to be more focused on is documentation. It's a very, very important issue. You're dealing with a client, there needs to be documentation of some of those discussions. So, it could be, like I said, oftentimes it's a key issue of determining whether an E&O claim is even brought against the agency, or if one is brought, it'll determine what direction the claim goes. Producers need to understand. Now, you may say, I remember that, it's not documented, but it's in your head. You remember that conversation. I've done a lot of expert witness work where I have seen firsthand that your memory does not carry any weight whatsoever in a courtroom. It does not have much credibility. It's only going to be considered hearsay. So those types of conversations need to be documented and potentially then documented back to the client. And as you can see here, when conversations develop, whether face-to-face, in person, etc., it's important that these conversations be documented and potentially memorialized back to the customer. So take, for example, the client calls you and says, you gave me a quote for cyber. I think we're going to pass on that. Well, the important thing is then you would document that. You would also then send the client an email or a letter, probably an email, saying, per our conversation, you are declining the cyber proposal that we provided you. If I misunderstood you, please let me know. Thank you for honoring us with your business. That's good documentation. If you're asked any kind of what I call what if questions, what if I get a drone? What if what if my kid goes to college? Once again, you want to be very careful how those questions are being answered, because there's a good chance that the client is documenting what you're telling them. So documentation should be handled promptly, accurately, should be detailed, the who, what, when, where, why, and should be generated typically by the person that had the discussion. Now, when you're on a sales call, let's say you're bringing one of your associates with you, there should be a clear understanding of who has the responsibility to be taking notes of the conversation, because that conversation should be documented in some manner. So it could be taken by you, could be taken by your associate, but it should be clear who has that responsibility. There's an expression that I've used many, many, many times, and many of the plus agencies that I work with know this: if it's not on the file, it didn't happen. If it's that important of an issue, it better be documented, because if it's not documented, it's not in the file, the courts are just going to say that's hearsay. It's your word against the client's word. You're going to lose more of those than you're going to win. We're going to move on now to discussion about carrier proposals. You send in an application to the carrier, they respond back with a proposal. There's a good chance that the proposal that you're getting does not provide all of the coverages that were requested on the application. So it's important that every agency have a process to review the proposal to verify what was provided and what wasn't. I know one agency that I work with, they found that in one situation, there were over 30 different coverages that they asked for that were not being provided. So you need to identify that. You don't want to assume that the carrier is giving you everything you asked for. And there could be situations that's like, well, yeah, they may say, yeah, we're providing that coverage. It's under this endorsement number. Well, maybe you want to ask for a copy of that specimen, that endorsement. Get a specimen form so you can see exactly what is covered and what is not covered. Most agencies, virtually all the agencies, this has been a big issue of the E&O Plus program, to have a standard proposal template. So chances are your agency has that template. We always work with the agencies to try to help you to refine that. It's important that these proposal templates be consistently used. They are typically going to contain key disclaimers that are going to protect the agency should a problem develop. Some producers say, well, I don't need that disclaimer on every page or whatever. Well, yeah, you do. These disclaimers should not be deleted from the proposal. Once again, They are very, very, very important. They could provide a defense if something happens down the road. The agency proposal is an admissible document. What I mean by that is if a claim occurs, the plaintiff attorney that's representing the client is going to have access to the proposal that you provided. And obviously accuracy is very vital. Education has been shown to be a significant factor of minimizing E&O claims activity. So always look for your proposals to provide some degree of education. You want to look to avoid use of the word recommendation. I know many folks, probably some of the more seasoned producers would say, well, they were brought up in the business by saying, well, we recommend certain coverages. Well, that's something that we're trying to discourage, because courts view recommendation as a potential heightened standard of care. It's almost that it's going to be viewed as that you telling the client, this is what you should have. Well, that's fine. But what if you don't recommend something and they have a loss in that area? They'll say, well, we didn't buy it because you didn't recommend it. So once again, what if you miss something? Most agencies, it's not possible to list every single coverage that the client should consider. So most agencies will look to include in your proposals a statement such as additional coverages to consider include, but are not limited to the following. And that is designed to say it's not meant as an all-inclusive list, but here's some of the key ones we think you should pay attention to. Now, while you would like the client to purchase all the coverages and the limits that you've noted in the proposal, there's certainly the possibility they may say, well, okay, we'll take the auto, we'll take the package, we'll take the D&O, the cyber, we really don't think we have an exposure. So I tell you what, we're going to think about that. We'll get back to you. So now you want to make sure that there's a clear understanding as to what was purchased and what wasn't. Many agencies will look at providing a binder for the coverages that were in fact bound with an additional notation saying there's no binder for the cyber, as you've indicated you were not interested in that proposal. So there should be some kind of a confirmation. Once again, a lot of agencies use an updated proposal to do this. It's also common to send the client a letter, an email, something to confirm the purchase decisions. You want to make sure that there's no misunderstanding as to what was purchased and what wasn't. Now, the client may say, well, I'll be back to you next week. You may say, well, okay, there's really no rush. Well, yeah, there is. It should be, if they didn't tell you right then and there that they wanted the coverage, then there should be some kind of a confirmation back saying, you said you wanted to think about it. When you've made a decision, please let us know. So this kind of gets into that issue. So if a client sends you an email with their decision, that's fine. Just make sure that have that email saved in the appropriate agency system. Now, probably from time to time, as producers, you have a lot of expertise, and the client may say, well, you've been in the business for a number of years. So let me ask you, what would you do if you were me? Or, what do you suggest? Well, that's fairly common, but you need to be very careful in commenting on those types of statements. It's important that the client really be the one making the decision. So client accountability is an important issue that agents should strive to achieve. And once again, that's why we really say avoid use of the word recommendation. Probably the best thing to do is say, well, in honesty, I'm not you. You have your own risk appetite. I can help you understand what's covered and what's not, but at the end of the day, you need to be the one making the decision. So, it's best to provide the client with education, knowledge to assist them in the decisions, issues such as providing limit options for various coverages. Once again, although producers are not responsible for notifying clients of every exclusion in a policy, it is fairly common from time to time that if you list exclusions, maybe, on the proposal, that to state exclusions include, but are not limited to the following. And that may actually, some producers have told me that has helped them sell more insurances, like on a general liability. Well, that employment practices is excluded. Well, the client may say, well, okay, I didn't know that. Can you give me a quote for that? So it might help you sell more insurance. Policy delivery, policy review and delivery, excuse me. Policy review is probably one of the more underappreciated elements of a strong agency E&O culture. When we look at E&O claims that have occurred in the program, oftentimes, that there's an error in the policy that the carrier issued that should have been caught and it wasn't caught, and could have a key issue in an E&O claim that develops down the road. So all too often, carrier issued policies do contain mistakes. I've had some agencies tell me that virtually every policy they get, there's a mistake in it. Well, it could be minor, it could be a comma in the wrong place or whatever, but there are some stories about some significant errors. There's one where, on a claims made policy where the carrier advanced the retro date without notifying the agency. Well, the error didn't get caught, and down the road, a year down the road, all of a sudden a claim was not covered because of the retro date issue. So it's important to review policies, and if you're going to outsource that, and that's fairly common, Resource Pro, Patra, et cetera, some agencies do that themselves. That's fine. The goal of policy review, whoever is doing it, is to determine whether the policies reflect the coverage that was requested and that was bound. So policy review, very important. And I always suggest that producers to be aware of certain issues, certain maybe coverage limitations, that before they deliver the policy, so they can bring those to the client's attention. So for example, protective safeguards endorsement. Well, it could be a situation where that the sprinkler system needs to be operational at the time of a fire. Well, if all of a sudden the client turns off the sprinkler system, they have responsibility to let the carrier know, and they need to know that if they turn it off, that they're essentially voiding any coverage for fire. So, if the policies contain limitations like this, it's always good to bring those to the client's attention. I know some agencies will actually have the client sign some of these various limitation endorsements just to acknowledge that they were brought to their attention. Now, as I mentioned early on, when we're talking about agency defenses, that there is clients have responsibilities as well. One of them is to read the policy. Now, once again, it's not a slam dunk, but if you can get the client the policy, the earlier you can get them the policy, they have an opportunity to review it. Maybe they'll catch an error in the policy and you can get it fixed before a problem develops down the road. Policy review and prompt policy delivery are issues that are part of an agency's audit process and part of the expectations. So making sure that there is a procedure for when policies, when they're delivered, that there should be an activity in the agency system, say, when was the policy delivered? And if you've got a situation, this is going to be fairly common, that, let's say you've got 5 policies for that client. You received 4 of the policies, so you still have that one, maybe it's the director's and officer's policy coming from London. Well, so you've got 4 policies. Do you want to wait until you get the 5th one before you deliver all of them? Well, our suggestion is deliver the ones that you have, and just advise the client that here is the auto, the package, the work comp, and the umbrella. The director's and officer's policy, we haven't received it yet, but I'll deliver that under separate cover when we receive it. Something along those lines. This is a big issue. Moving coverage or renewal. Probably one of the biggest issues generating E&O claims in the program. The key issue is that when you remarket an account, there's the possibility that the replacement coverage is not equal to the expiring coverage. So, the issue is to kind of look to compare proposed versus expiring. And if there are any deficiencies, and I know one that was brought to my attention by one of the agencies that I'm honored to work with, it's like when we move the coverage, they wound up going from 100,000 ordinance and law coverage to 10,000. Should we have brought that to the client's attention? I said, yes, you should have. That's a significant issue. So, that should have been taken care of. So you want to bring them to the client's attention, and then, get some kind of a sign off, that acknowledgement that these were brought to the client's attention. This is the last item. So we're just about at the end of the time period. I very much appreciate, once again, your folks being part of this. Hopefully you find it very beneficial. one of the key issues that, and this was brought to my attention by some of the Allianz claims folks, a concern that from time to time, producers are admitting liability when there's a problem. And what could we do as reviewers to identify that, to help educate the agencies on this issue? So, unless the Allianz claims folks have been consulted, this is definitely an issue that you want to avoid. Why does it happen? Well, oftentimes, as a producer, client brings something to your attention and you may feel bad. It's like, oh, they don't have coverage for this. I wonder, maybe I screwed up here. You may feel bad. You may be of the belief that the uninsured loss is your fault. So, or maybe the claim is, well, it's not that big of a claim. So we'll get it paid out of the agency will pay that. So the key issue is that when you admit liability, there's certain agency defenses that now cannot be brought up. The premise of E&O coverage is based on legal liability. So just because the client has a loss that's not covered doesn't mean it was your fault. So you need to be found to be legally liable for the E&O policy to respond. So some of the defenses may include, well, the agency had no duty really to advise. The client was aware of the absence of the specific coverage. Maybe it had been brought to their attention, or the client, they had a duty to read the policy. So you want to be very careful as a producer that you're not out there admitting liability. Another key issue, and probably, equally, if not more severe, is that it could be viewed as a violation of your E&O policy. There's very strong language in the E&O policy addressing avoiding issues such as engaging in any settlement activity concerning any claim without the written consent of Allianz, admitting any liability without the written consent, et cetera, et cetera. The E&O Plus program has got very, 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 Gina and Frank are phenomenal claims folks. They're there to help you. If you have a question, whichever one of those you are assigned, you've got an issue, pick up the phone, talk to them. They'll guide you through the process. There's a good chance that, they may say, okay, if you want to go ahead and do that, we're going to get you a release to have the client sign that to make sure that nothing further causes any harm down the road, et cetera. I mean, you may want to make a goodwill payment. Once again, you want to speak to the E&O carrier to discuss the matter to determine any issues that need to be addressed. So this pretty much brings us to the end. So we're pretty much right on time, target time-wise. Once again, I hope you did find the session informative, educational. Producers, you play a huge role in the agency, not only in the success, but in determining the culture of the agency as well. So hopefully some of these things will resonate with you, and we can all work towards reducing the number of E&O claims out there. So thanks again. Gina, or Jan, back to you.
Okay, we have only one question. Review again why a coverage checklist with documentation in writing is important. Should this be done at least annually before renewal?
Well, okay.
Why a coverage checklist is important.
Yeah, well, checklist, once again, a client, there's a good chance that your client's exposures are changing. Or your goal is, as an insurance person, if you can help to identify certain exposures that now you bring it to the client's attention saying, you don't have any coverage for this exposure. Now, the client says, well, that's okay. I really don't want coverage for that. That's fine. But you've now brought it to your attention. So especially in the beginning, when you are trying to write an account, one of the key issues probably as a producer is to try to find what they call the pain. What is the pain, that the client maybe is experiencing? Maybe they had a loss that wasn't covered, so they're somewhat upset. Or you can bring to their attention, say, hey, you have this exposure. Do you know you don't have any coverage for that? Well, that's a way for you now to show value as an agent. And then moving forward, there's a renewal process. Your client's exposures are changing. So you take personal lines, where also now you have, maybe you have a personal lines account that is, they're now driving for one of the ride sharing companies. Well, there's not going to be any coverage under the personal auto. So that's an exposure maybe that they didn't have before. By bringing it to your attention, you now can help guide them through the process. We talked about the issue of drones. Drones is becoming much, much more of an exposure. And I think there's some real questions as to what degree does the general liability policy cover for that. So maybe they didn't have that drone exposure last year, but they do now. And by identifying that exposure, you can now provide them with a proposal and hopefully sell more insurance. And if they don't want it, well, you've now covered your back. You're covered your back. That okay, I brought it to their attention. They're not interested in the coverage. Fine, you've got the sign off. So now, if something happens down the road, you've got a strong defense. So exposure analysis is a huge issue. It's going to help you sell more insurance. It's also going to reduce the exposure of your agency.
Okay, thanks, Curt. And that was the only question we had there. So thank you very much for that informative presentation. And everyone, please note that you'll receive a passport announcement via an email from me, including instructions for using a link to view the webinar. And a PDF version of the PowerPoint that you saw on your screen will be included in that announcement. And we'll also convert the webinar to a YouTube and send that link in the announcement as well. So you'll have several ways to view this webinar. And if there are no further questions, this now concludes the webinar. Thank you all for attending.